The tea is hot this morning, my lovely human. So I am still in my jammies and stuff. I did take my hair down so that when I go to search for these, they're a little easier. But I was so exhausted and yawning and like barely holding it together when I tried to do this video after the other one last night. So I just decided we're going to start fresh in the morning and we're going to make the tea super fresh. So what we have going on today, the big pop-off, is that Judge Canone is getting sued. Now, it's not just Judge Canone who's being sued. I will put down here the list of other court peoples who are also getting directed at with this lawsuit / complaint. This complaint is by a group of plaintiffs who are protesters who are saying that the buffer zone that Judge Canone ordered violates their rights to free speech and to protest. The reason why this is a separate video from the other one is because even though it's tangentially related to the Karen Read case, but not about her or the witnesses directly in that case, this is about Judge Canone getting sued on a different matter for herself. So that's why, even though it is related to the trial, it's a separate thing, hence a separate video. I hope that makes sense. I hope I explained that well. So as you all may know, the Karen Read trial is a very high-profile case, hence there's YouTube videos out the wazoo about it. And it also garners local attention, and there have been, in every high-profile case, there is protest. There are people who hold their signs and express their opinion, not in the courtroom. Now, with that in mind, this happens with many high-profile cases. Another thing that is common in high-profile cases is what is called a buffer zone. So this is where typically the space around the courthouse, including the areas nearby, directly across the street, and in the parking lots around a courthouse, those are usually protected by a buffer zone so that you can't have people right outside, the courthouse window chanting, "Lock them up" or "Let them go." It interferes with the court process and procedures for numerous reasons. One, it can cause undue stress and bias to the jury, who have a protected privilege of being jurors, which means they are only supposed to be influenced by the presented evidence in court. What the witnesses say, they are supposed to interpret them as credible or not, experts as credible or not, and then any pictures, videos, etc., they are allowed to take in that information that is presented in court as is and make deliberations and a verdict based on that alone. They are not supposed to be pressured or have to endure pressure from outside society to make their decision. Because it's not about what the public likes, it's about what the evidence presents. That's what it's supposed to be. So having people chanting in or really close to the courthouse, or people with megaphones, etc., that can cause interference. Not only does it make it hard to hear, it's very distracting. Jurors might not be paying attention or able to pay attention, nor could anybody else, because of loudness. And it's just a general protection thing. So having high-profile cases where there are people who in the public who have strong opinions that they express, having that buffer zone is not uncommon. And one of the main reasons why Judge Canone had ordered the buffer zone in the first trial and in this trial is that the loudness was one of the things. It was very hard to hear in court, as was, and if you watch the first trial, people were intentionally honking their horns when they were at or parked near the courthouse. There were people who had to be asked to be moved because they were using volume enhancing things, blow horns, etc. And again, you can't just have people chanting whatever their opinions are, influencing the jury. So those things were issued. The difference is, the reason why Judge Canone is getting sued about this buffer zone is because of her expanding it. It was already a 500-foot radius around the courthouse and the parking lots, etc., which, again, I said, very common. But now she has extended that to include several other places, not just the Dedham Courthouse and parking lots, but also I believe it to be Ames Street, Court Street, and I lost my place, hold on, Bates Court, and Bullard Street. All right, I found where I was supposed to be. And the plaintiffs who are arguing that Judge Canone is going outside of her jurisdiction to make this buffer zone, and it's not because of a noise ordinance, that she's not doing it to protect the jury from becoming biased or influenced from the outside, that she's using those as a pretext because she is essentially butthurt about the things being said about her. Yes, many people, myself included, have a lot of criticisms and problems with Judge Canone, her rulings, and what I and / we have interpreted to be her bias. One of the plaintiffs in the courthouse, they have an exhibit. This is the exhibit of one of the plaintiffs holding up signs that are, of course, criticizing Judge Canone, calling her having a clown house instead of a courthouse, saying that she's contradicting. And there have been other signs and stuff that indicate that they're not pleased with Judge Canone. And the lawsuit here is saying that this buffer zone isn't to protect the defendant's rights to a fair trial, which are protected by the Sixth Amendment, that it is just because Judge Canone herself is upset about the criticism being directed at her, and so she is falsely making this extended buffer zone that is unnecessary just for the sake of trying to keep people from criticizing her or dealing with the criticism towards her. They also claim that the reason why this is a violation against their 14th Amendment and First Amendment rights is that the larger buffer zone includes public fora, and it includes stuff like private residences and the public library. And they're like, you can't tell us that the stuff we pay for, our tax dollars pay for the public library. You can't tell us that we can't use it. That's not in your jurisdiction. And you certainly can't, according to the plaintiffs, they are saying that it is outside the judge's jurisdiction to tell them that they can't put signs or posters in their private yards and residences expressing their opinions. Because the way that it is, that the individuals are prohibited from using audio enhancing devices, and that no individual, so nobody whatsoever, may demonstrate in any manner. So this covers everything, and this is why they're claiming that it is overly vague and ambiguous, is that just anybody can't do anything. That's what they're saying. They may not demonstrate, which means signs, buttons, t-shirts, anything. Even if they're not saying stuff, you're not allowed to wear a t-shirt on Ames Street. In any manner, including carrying signs or placards within 200 feet of the courthouse complex during the trial of this case, unless otherwise ordered by this court. The complex includes the Norfolk Superior Courthouse building, the parking area behind the Norfolk County Region of Registry Deeds building. The buffer zone shall further extend to be the area, and then those 4 other streets that were already mentioned. And so you can't be using blowhorns and megaphones to try to reach the courthouse ears if you're outside of those jurisdictions or outside of those limitations. And you also can't be just you cannot do any demonstrating, can't even have a button or anything like that, according to this. And they're saying that that is an overreach of Judge Canone's power, that the buffer zone is extending into their personal lives and is violating their rights. They also have in the complaint that Judge Canone has not allowed for them to intervene. So what this means when you intervene in a courtroom is you're not a part of the prosecution or Commonwealth, you're not a part of the defense, You're an outsider who feels like whatever order the judge has done is affecting your ability to have your rights be met. So anybody can go in and present their case to the judge. It is a protected right to intervene. However, Judge Canone said, no, I'm not allowing anyone to intervene and speak differently on behalf of the buffer zone. So she is taken away those rights and is thus in violation again. That is a part of the lawsuit. Now, of course, you can't just go into the courtroom and go, I don't like that order you did, Judge. No, the right to intervene is only if you are affected in some way. And Judge Canone has refused the plaintiffs the ability to intervene, even though they are being affected, because they are people who are protesting and demonstrating and now are being told that they can't do it even on private property. So I'm going to skip through here. You can follow along with me over here, but some of the other issues that are in effect of this lawsuit are the plaintiffs wish to continue to demonstrate, including criticizing Judge Canone off the grounds of said courthouse complex, but within the buffer zone during the second trial. So again, they're putting in that it's not about protecting the client or the defendant. It's not about protecting the jurors. Judge Canone just doesn't want to hear criticism about herself. And all of the plaintiffs involved in this are ones who were specifically said that they were quietly demonstrating with signs, that they were not using audio enhancing devices or honking horns, that they were just holding up signs that she found distasteful, like I showed you before. Then they said that the courthouse, or that the court order is, the buffer zone is just too big and in violation of their rights. The next thing is the plaintiffs reasonably fear that Judge Canone will attempt to hold them in contempt if they engage in demonstration or otherwise attempt an unconstitutional act to suppress those who would criticize her publicly. Once again, touching on the, she doesn't want to deal with the criticism and is violating rights for her own, to protect her own distaste. And if you violate a court order, you get found in contempt and can get arrested. Yeah, you don't violate court orders. But they're saying that they have a right to demonstrate, but if they exercise that right, she will hold them in contempt. And I fully believe that that is completely reasonable. Judge Canone absolutely would. She wouldn't have a problem with that. The next thing is number 33. Plaintiffs reasonably fear that the Norfolk DA will, under the control and direction of defendant Morrissey, will seek their prosecution for violation of the order if they engage in a demonstration. Again, yeah, they will get prosecuted for violating a court order. The number 34, as the Denton police officers took action to enforce the buffer zone during the first trial, plaintiffs reasonably feared that the Denton Police Department, under the control and direction of the defendant Morrissey, will arrest them for violation of the second prior restraint order if they engage in such a demonstration. Again, they usually do have law enforcement to ensure that buffer zones don't get violated, that they don't have crazy people running into the courtroom or into trials and such. So that's not an unusual or out of the world suggestion. Then number 35, as the Massachusetts State Police officers took action to enforce the buffer zone during the first trial, the plaintiffs reasonably fear that the state police, under the direction of the defendant Noble, will arrest them. So you have to show that you're being affected, and that, and so they're saying that they will feel repercussions of their rights if they do that. And we do have a very interesting First Amendment right that any other country does not have. You can't criticize governments in other countries. In some countries, you get if that happens, right? So they're saying that they have a right to protest. Continuing on, this is the next part here. This is the second part. Approved of the 200 additional larger ill-defined area Contrast with Cox versus Louisiana, 379 U.S. 559, 1965, they're stating case law. This is an over-inclusive. It includes speech in private businesses and homes and in traditional public fora. Mainly that would be directed at the public library that apparently is also included in the widened buffer zone. And it's under-inclusive as it doesn't regulate any other forms of speech directed at potential jurors, the ostensible fair trial reason given. Okay, I don't really think they needed ostensible there. That's just for drama. But they're saying that, saying you could say, the police work sucks or something. It's stuff that would impose a fair trial. It's specifically content related, and that's where they're having a lot of their main issues, is that it's not just that they're not allowed to demonstrate. They're specifically not allowed to demonstrate about the Karen Reed trial and about Judge Canone. The second prior restraint order says to address noise and minimize the prospective jurors' exposure to viewpoints about the Reed case. But it's targeted to speech that in the ambit of the Reed case, when Judge Canone in the Superior Court routinely conduct jury trials without such restrictions. Okay, so I think that one's a bit of a stretch. It's basically saying we'd be allowed to demonstrate closer to the courthouse and within a smaller buffer zone for anything else. Why is this special? Well, one, because it's a high-profile case. Most cases, because court happens every day. There are trials that happen every single day, 8 to 10 hours a day. That is what is happening. Judges and lawyers go to work every single day like all the rest of us. So, now, the targeted speech related to the Reed case, well, yeah, you're not going to have a buffer zone about a case and not be allowed to say the yellow bubble gum is the worst. I think that one's a stretch. I do understand what they're trying to say, that they're once again just trying to additionally say that it's really about Judge Canone, not about anything else. Judge Canone could have taken other measures to reduce jurors' exposure to noise and public speech without imposing content-based restrictions. This is a much stronger argument because when judges are doing buffer zones, it is a part of the federal system that that you're supposed to choose the way of least resistance. Can this be solved without extreme measures? That's the way that it is intended to go. So Judge Canone could have put in an order that says, you can wear all the t-shirts you want, you can hold up all the signs you want, but you can't use any, speakers with megaphones or microphones or blow horns, etc., that cause excessive noise. There are other ways, and noise ordinance is what she could have put in and said, okay, listen, you have to be quiet in this area during trial, right? She could have said something like that, which would have solved her main reason that she claims she did the buffer zone. The second prior restraint order, this is number 40, is unconstitutionally vague. The plaintiffs cannot ascertain as to where they may or may not demonstrate, as the purported bounds are not bounds at all. Plaintiffs cannot ascertain exactly what speech is prohibited. It is unclear if they can wave political signs that say vote against D.A. Morrissey or Judge Canone is corrupt. Okay, so this one is claiming that, they said that it's over-inclusive. That you just can't say anything about anybody is how the buffer zone is currently phrased. And because of that being so over-inclusive, it's also vague. It's just, anything. We're going to be able to claim anything is going to violate this. And they also are because it's saying stuff about the Reed case, but if you're vote against D.A. Morrissey, how people have the political signs in their yard about who they are or are not voting for or who they encourage or want to win in any given election. Those are elected positions. And it's also, even though, again, if you're putting Beverly Canone runs a clown house, that's a little different than saying she's corrupt. And it's also, they're also saying that the purported bounds are not bounds because you can't tell me what signs I can and cannot put up in my yard. Some places do have restrictions of how large a sign in your yard can be, and those people almost who want giant signs almost always try to go to court over it. It's quite the thing. So that is what they have going on there. So Judge Canone getting sued. What do you guys think? I think the buffer zone is too big. And it's hard to tell with Judge Canone because on one hand, I can see her not giving a bleep what people say about her. I could also see her getting very butthurt. She kind of rolls both ways. She's hard to read sometimes. So it's just, could I absolutely see her being butthurt? Like, you know what? I don't need to hear this from you. Go all the way over there and with your running mouth. I could also see that I really don't care what you say about me. But she has always been very, very protective of jurors. So she's like, I really don't care that you think I run a clown house, okay? I do care that you are making statements that are going to impact my jury. Go over there. And she didn't just do this on her own. The Commonwealth is also, the DA is also getting sued under this lawsuit. So what do you think? Is the buffer zone there to protect the noise that absolutely did interfere in the first trial? And they're like, listen, what we have going on is too small. We need to get them back a little more. Or do you think that just putting in a noise ordinance, if that was the main problem, indeed, and not criticism towards the DA and Judge Canone, and the DA and Judge Canone, by the way, were two of the people that have some sort of personal, plausible, alleged relation or personal connection to each other, hence why the defense had wanted her recused in the first place. Or that was one of the main reasons, is that she has some kind of outside relationship with DA Morrissey. So what do we think? Do we think that Judge Canone is just outreaching, or is she like, I have to try to keep this trial fair and unbiased, and I need you to go away? Tell me what you think. I think that a noise ordinance would fit that, and I think that it is an overreach to tell people in their private residences that will be affected by this extended buffer zone that they can't carry signs or wear t-shirts. You can tell people to physically shut their mouths and still let their opinions be expressed. Because if people are just holding up or putting up signs or wearing shirts or buttons that say something and they're not projecting it into the atmosphere verbally, then whatever happens in the courthouse is not going to be affected by that. So, there we go. That is what's up with that. I will see you in the next video, my lovely humans. We're caught up. Here we go.